have with us Honorable Shri Justice G.S. Patel, who is our special invitee for this evening. So we wish both the teams good luck, and without any further delay, we shall now commence with the final round of arguments.
The council seeks permission to proceed with the pleading.
Yes, please.
Yes, please.
Obliged, Your Lordship. This is counsel on behalf of the petitioners in the matter of Nonita Chandran on behalf of the Mohaya community versus State of Gridor and Government of Primrose. This is counsel number 1 and would be dealing with issue 1 and would be taking 15 minutes of this court's precious time, whereas my co-counsel would be dealing with issue 2 and 3 and would be taking 13 minutes of this court's precious time. Respectfully, 2 minutes are reserved for rebuttal. The council seeks your permission to state the facts of the case in brief.
Yes, please proceed.
Much obliged, Your Lordship. The Republic of Primrose is an agrarian and a rural country home to diverse ecosystems. In order to protect the same, the Parliament enacted the Primrose Wildlife Protection Act in the year 1972. In the year 2006, to correct the historical injustice against the forest-dwelling communities, the Primrose Parliament enacted the Primrose Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act. This act fueled a debate between the two schools of environmental protection. After a huge protest in the state of Gridor, the state government started the process to identify and demarcate critical wildlife habitat. In the Moha Wildlife Sanctuary, 2 critically endangered species were identified, the little Mary lark and the Oliver antelope. The Mohaya Wildlife Sanctuary also housed the Mohaya community who had been granted community rights under Section 3A, C, and D of the Forest Rights Act of 2006. The expert committee therefore identified 15-kilometer stretch in the Moha Wildlife Sanctuary, including the area of the Lazy River for the proposed critical wildlife habitat. At the open consultation held by the expert committee, the members of the Mohaya community raised their objections to the proposed critical wildlife habitat. They stated that they have been living in peaceful coexistence for generations and that their livelihood and their cultural practices depend on the proposed critical wildlife habitat. They also stated that the expert committee has discarded other factors which may have led to the decline in the number of the endangered species. The expert committee, in reply to the same, merely stressed on the harm caused due to the presence of the Mohaya community and, in response to the objections, claimed the precautionary principle. After consideration by the designated authorities, the Moha critical wildlife habitat was declared the first in Primrose. Aggrieved by the same declaration, the petitioners are here under a public interest litigation to preserve their rights. The council now seeks the permission to proceed to the first issue at hand.
Yes, please. Yes, please.
Much obliged, Your Lordship. Your Lordship, the first issue at hand is whether the declaration of the Moha critical wildlife habitat modifying the rights of the Mohaya community is valid and reasonable. Your Lordship, it is the humble submission of the petitioners that the same is invalid and unreasonable. The argument...
Ms. Counsel, did you not have an alternate remedy perhaps before the National Green Tribunal or to challenge the consent granted by the Gram Sabha under this very legislation, particularly under Section 6.2?
Indeed, Your Lordship. However, with regards to Section 6.2, Your Lordship, Section 6 deals with recognition of rights. So, wherein there is a disagreement between the parties in the Gram Sabha with regards to recognition of rights, the parties are supposed to go and seek a remedy under Section 6. In the present matter, the jurisdiction of the National Green Tribunal has not been evoked, is because the petitioners are here in front of this Honorable High Court under Article 226 for preservation of not only their legal rights, however, their fundamental rights as well. So therefore, with regards to a plethora of cases by the Honorable Supreme Court, the jurisdiction of this Honorable Court under Section 226 is wide, and therefore the petitioners are humbly appearing before this court for the same.
Okay. You may proceed with the first issue.
Much obliged, Your Lordship.
Yes.
Your Lordship, the argument for the first issue will be dealt in a threefold manner. Firstly, that there is a violation of Article 14 of the Constitution of Republic of Primos. Secondly, that there is a violation of Article 21. And thirdly, that there stands a violation of Article 29. Moving on to the first fold, that there is a violation of Article 14, the first aspect of the same is that the declaration is arbitrary in nature. Your Lordship, the Council would like to draw your attention to the rule laid down in the case of E.P. Royappa versus State of Tamil Nadu, wherein the very essence of the rule of equality laid in the anti-arbitrariness. Your Lordship, the concept of arbitrariness has been defined in various judgments like that of Sharma Transport versus Government of Andhra Pradesh, wherein it was said by the Honorable Supreme Court that any action which is done capriciously or at the pleasure without adequate determining principle would amount to an arbitrary action. Your Lordship, drawing your attention to the facts in the present matter, the committee on its whims completely ignored the construction of a road which was done 5 years ago that cut through the Moha Wildlife Sanctuary, leading to massive deforestation, and that the particular area was also open to tourism. Your Lordship, wherein the identification of the critical wildlife habitat was primarily done on the basis of preservation of the endangered species, it is rather absurd that a crucial fact like this was very conveniently omitted. Your Lordship, furthermore, I would like to draw your attention to the case of Ramakrishna Dalmia versus Justice Tendolkar on page 2 of the memorial, citation 8, wherein it was held that where the statute lays down a principle to be followed, but the executive fails to adhere to these principles, the executive action should be condemned as unconstitutional. It is a humble submission to this honorable bench that in the present matter, the expert committee has also failed to objectively and rationally assess the reasons behind the reduction of these species. Talking about the first species, which is the Oliver antelope, Your Lordship, if you would draw your attention to para 9 of the para 10 and 9 of the Moot proposition, it is clear from the same that the expert committee did not have any strong or substantial proof, and merely on the belief that it might be due to the activities of the Mohaya community, have held them responsible for the same. Furthermore, Your Lordship,
this council, as against an expert committee report, what is the standard of judicial review that we should adopt? Your submissions are more in the line of as if we were hearing an appeal against the order. Do we have that kind of jurisdiction?
Indeed, Your Lordship. Your Lordship, with regards to this, definitely this court has in various cases by the Supreme Court held that the court cannot appreciate and delve into the findings of the expert committee. However, the submission of the petitioner herein is not for the court to delve into the findings. However, it is merely to acknowledge the fact that a crucial consideration was missed. So, wherein a finding was not even considered by the expert authority, the petitioners merely pray that the expert committee should be taken into consideration, as the Honorable Supreme Court has done in the case of Mahabir Coke Industry.
Yes, Madam, your right flows under the FRA Act.
Indeed,
Now, the creation of the critical wildlife habitat is also a provision under the same enactment.
Indeed.
Now, if you go to the factual data, the community, your community is occupying 4 hectares of land in the sanctuary. Now, out of this, what is the expert committee has identified only 15 square meter stretch to be declared as the protective habitat. Now, this approximately comes to 0.0015 of hectares. So, it is the bare minimal that you are going to sacrifice, and of course that is the justification is this by applying the precautionary measure as well as the fundamental duty of the state to protect the forest and the environment. So why this why this action can be said to be arbitrary according to you? Because it's the bare minimus de minimis theory which can be applied.
Indeed, Your Ladyship. Your Ladyship, with regards to this, firstly, I would like to point you to para 9 of the Moot proposition, wherein the expert committee has identified 15 kilometers stretch as the Moha Wildlife Sanctuary as a critical wildlife habitat. Your Ladyship, with regards to the precautionary principle, there has to be a reasonable apprehension behind the same. as the council was already pointing out, that there are no objective reasons for the committee to believe that it was the activities of the Mohaya community that have led to the decline of the endangered species. Your ladyship, furthermore, the council would also like to point out that with regards to the other species involved, which is the little Mary lark, the committee has relied on satellite imagery to actually see that there was a decline in the tree. This, however, does not reveal the reason behind the decline in the shingla trees. Your ladyship, furthermore, the Honorable Court has also in various cases held that satellite imagery may not reveal the complete story and cannot be used as a primary evidence.
No,
Therefore,
but is it not a fact, Miss Counsel, that these leaves of these trees are being put to use for the purpose of earning your livelihood? So there is no denial of the fact that you thrive on that.
indeed, your ladyship, the council does understand your concern. However, what the council herein is trying to plead is that the community only depends on mere collection of the leaves, a collection of the shringa tree leaves for their bare minimum survival. However, the same would not in any way result into the decline or deforestation of that very species of tree. Furthermore, it is not only the leaves of the shringla tree which are collected, there are other tree leaves which are also collected with as a part of the minor forest produce.
So are you ready to make a statement that if you are not going to trade in these leaves, then probably the issue would be really can be curtailed down the discord, because these species, they say that these particular trees are the breeding ground for these particular species. So if you give a declaration that you are not going to trade in these leaves, then probably the whole issue as far as this species is concerned would wither away.
Your ladyship, with regards to that, as I've already pointed out, that the collection of tree leaves cannot be extended to an aspect wherein there is a decline in their nesting habitat. There is no loss of timber. If your ladyship would refer to the meaning of minor forest produced under the FRA general definition clauses, it says that it includes all non-timber forest produce. So therefore, your ladyship, wherein there is no harm to the nesting tree, there is no harm done to the very timber, very branches of the tree, which is the nesting habitat of the little Mary lark, the same cannot be drawn to be a cause, to be a result of the activities of the Mohaya community.
Okay.
If your ladyship is through, the council would like to proceed.
Yes, please proceed.
Much obliged, your ladyship. The council would also like to draw the honorable bench's attention towards the principle of Wensbury's unreasonableness, which applies to administrative action. Your lordship, in the present regard, the courts would have to see whether there is a relevant factor which has been omitted, and secondly, whether whether the decision is so absurd that no reasonable person would have concluded with the same. Your lordship, as already established, relevant factors were omitted in this case. And secondly, the same is absurd to the extent that cohabitation as an alternative remedy was not even considered. The blame was completely laid down from the first instance on the Mohaya community without any causation or correlation whatsoever. Your lordship, secondly, there is an aspect of proportionality that has to be satisfied for a restriction to be reasonable in nature. For specifically in cases of environmental law, it has been the opinion of the Honorable Supreme Court in the case of Hanuman Lakshman Aroskar versus Union of India on page number 4 of the memorial that doctrine of proportionality has to be applied and satisfied in matters regarding to the environment. The part of the proportionality test is a necessity test which has to be fulfilled, which says that infringement of human rights in question has to be by least restrictive alternative. Your ladyship, in the present matter, the least restrictive alternative is that of cohabitation, which could have easily been considered. But since the same has been completely ignored by the respondents, the same test does not fulfill the proportionality ground. Furthermore, this honorable state in various policies like that of National Forest Policy of 1988 has substantially relied on creating a symbiotic relationship between the tribal people as well as conservation.
Council, just 1 minute. You know, there is a definition in the FRA of what is critical wildlife habitat.
Indeed, Your Lordship.
So how do you justify that definition vis-a-vis your argument of cohabitation and the principle of proportionality and the policies of the government? I think you need to refer to the definition to interpret the definition rather than to go on the other footing.
Indeed, Your Lordship. Your Lordship, with regards to the definition clearly says that that the area declared to be a critical wildlife habitat has to be an inviolate area, which
Yes.
means that it has to be free from any presence. If this, apologies, Your Lordship, if the same has to be read in consonance with the procedure laid down, it sufficiently says that the under section 4 there has to be a consideration of cohabitation which has to be made as a part of the procedure, as a part of the mandatory procedure, therefore.
Where do you
So
get that from?
Your Lordship, if we would refer to section 4 clause D, I think the same would be on your screen. Section 4 clause C, Your Lordship, that the state has concluded that other reasonable options such as coexistence are not available. If Your Lordships would allow the council another 2 minutes to just sum up with the arguments.
Yes, please. Yes.
So carry on.
Okay.
Much obliged, Your Lordship. Your Lordship, therefore, with regards to the definition and what the declaration's effect on the rights of the community would be, is the same, that they would have to leave the area that they've been occupying since generations, which they also have duly recognized rights under the FRA for. Your Lordship, the second limb of the argument, therefore, is that there is a violation of Article 21 vis-a-vis the right to life and right to livelihood. The easiest way of depriving a person of his right to life would be to deprive him of his livelihood. So therefore, wherein the community depends on the fishes of the lazy river for and collection of the minor forest produce, as per para 10, the same declaration would deprive the petitioners of their duly recognized rights under section 3C and section 3D of the FRA. Furthermore, Your Lordship, it has been held in the case of P. Rami Reddy versus State of Andhra Pradesh on page 8, citation 38 of the memorials, that it is not mere access, but actual availability and possession of land that is indispensable to the livelihood and subsistence of the tribal communities. With regards to the same, the council would like to move to the third aspect of the argument, which is that the tribal communities have a fundamental right under Article 29 to conserve their distinct culture. Your Lordship, in the present matter, there is a 100-year-old banyan tree which the community has been worshipping since generations that falls within the proposed critical wildlife habitat. Therefore, with regards to protect such a right, which is also derived from various international conventions like the UN Declarations on the Rights of Indigenous People, to which the Republic of Primos is a signatory, there is the obligation on the state to fulfill the same. There is an obligation on the state to not forcibly remove these people from the area they have been occupying since generation, and that they have the right to practice as well as to revitalize their cultural traditions.
What do you think? You would need a modification of their rights?
Your Lordship, with regards to the same, the FRA allows for a modification. However, in the present matter, if you would refer to the clarifications, therein, their rights under section 3A have not been retained at all. So wherein their rights are completely taken away, the same declaration is unreasonable as well as invalid. If your Lordships are through with the submission, the council would like to invite the co-council to deal with issue 2 and 3 at hand.
Yes.
Much obliged, Your Lordship.
Thank you. Thank you very much.
Thank you.
Very pleasant greetings of the day to your lordships. This is council number 2 on behalf of the petitioners in the present matter, and the council will be dealing with issue number 2 and 3. Issue 2 is, if not, what are the recommendations for the integration of the Mohaya community with the Muha critical wildlife habitat? Your lordship, the council would like to very humbly submit that the tribal and indigenous people have a very distinct and intuitive relationship with the wildlife. They have acquired a wealth of traditional knowledge, and they have
Mr.
applied the
Council,
same.
you are not visible. Mr. Council, though you are audible, you are not visible.
Indeed, your ladyship, that might be because of the limited screen space. The that could be because of technical errors or something. If you will kindly move towards the top of the navigation, you might find different windows wherein you might be able to see me.
Yes, yes, I think we
We
can
can
see
see
you.
him. Yes.
Uh,
Yes, yes, we can see him. Yes.
we'll have to click on the top right-hand corner.
Yes, yes, yes,
Uh,
yes,
am
please.
I okay? Much
Yes.
obliged to ladyship. The council would like to submit that these indigenous people have managed and conserved their lands for over centuries, Your Lordship. And their practices are also very widely recognized as also accepted under paragraph number 5 of the Moot proposition. Similarly, Your Lordship, these practices are also taken into account by various international organizations and is a part of various international treaties as well, to which the country is a signatory. To this effect, the Council would like to draw your Lordship's kind attention to the Rio Declaration. Your Lordship's the Principle 22 of the same states that it is very important to ensure cohabitation. Similarly, Your Lordship,
Mr.
Article
Council,
11.
if there is a conflict between an international treaty to which the country is a signatory and the municipal laws of the same country, then what is to prevail?
Indeed, Your Lordship, the domestic laws would prevail, but Your Lordships, in the further arguments, the Council would substantiate that the government of the country has created various policies which also support the same. As we will proceed with the further arguments, the Council would substantiate on the same as well, Your Lordships.
Oh, yes, please proceed.
Much obliged, Your Lordship. Your Lordship, similarly, Article 11 of the Convention of Biodiversity also encourages party to strengthen their relationship with the indigenous and local communities in order to promote a sustainable management of the wildlife. Your Lordship, similarly, there are various examples that can be seen across the globe wherein the community-led forest conservation has provided great results. Your Lordship, the Council would like to firstly present the example of Biligiri Rangaswamy Temple Tiger Reserve, wherein the tiger population had almost doubled in a very small period of just 4 years. Similarly, Your Lordship, similar studies can be seen across the globe, and examples from African communities are very widely praised for the same. And a similar example of the same is also shown by the Kenya's Lipikai Masai community, which owns the only rhino sanctuary of the country. Your Lordship, there are depleting resources. The resources are getting lesser and lesser with time and climate change. But even after that, the community has shown that coexistence in a very harmonious manner is possible. Not only the wildlife is protected, wherein communities are managing the forest, deforestation is also very less or is actually next to zero, Your Lordship. To this effect, the Council would like to draw Your Lordship's kind attention on a paper on combating climate change, which is also cited as authority number 66 of the Moot proposition, which states that uh, for over more than a decade, that is, Your Lordship, from 2000 to 2012, deforestation in community-led areas was 1% as compared to 7% outside them. Your Lordships, all these parameters needed to be taken into consideration before we take any substantial decisions which will impact the lives of millions of peoples. Your Lordship, it is very pertinent to note that the committee with the satellite imagery found that the number of shingle trees is reducing. Whereas, as also argued by my learned co-counsel, that the community merely relies on the minor forest produce, which does not take into consideration, which does not rely upon such timber. Your Lordship, if your Lordships may kindly refer to paragraph number 9 of the Moot proposition,
Yes.
it is very clearly stated that the reasons for the reducing of the Oliver antelope was not even known. And as per paragraph number 11, it clearly states that the committee on its belief and merely stress the harms of the same on the community, Your Lordship. So wherein the expert committee is functioning on merely a belief, the same cannot be said to be just and fair, Your Lordships. Your Lordships, the
Mr. Council, we appreciate that you purport to represent the community as its leader. But in the Gram Sabha consented this proposal. So what do we take from that?
And
Indeed,
you
Your
also
Lordship.
participated. You also participated in the open consultation. You were afforded an opportunity.
Yes, absolutely. My sister has pointed that out.
Indeed, Your Lordship and Your Ladyship. Your Lordships, it is very important to note that just giving an opportunity might fulfill the statutory obligations, but the same has to be fair and just. Your Lordships, the expert committee did not take into consideration any of the points raised by the community, as well as at the open consultation, whatever points were raised were not even replied back to them, Your Lordships. Similarly, Your Lordship, the points were also raised with the help of the Gram Sabha, and thereafter the consent was given, which Your Lordships cannot be said to be free from encumbrances because the Gram Sabha had also raised similar doubts. Because Gram Sabha is actually made of the people of the community who themselves are raising various questions to the same, Your Lordships. Your Lordships, the fact that the community did not take into consideration all the aspects is of great importance because the impact of the roads on ecology is very, very high. Your Lordships, to this effect, the Council would like to refer you to a study by Yale School of Environment, which is citation number 63 of the 68 of the written submissions, which states that the biophysical aspects such as dust have been shown to impact not only vegetation but also the animal movement, Your Lordship. Similarly, Your Lordship, when we create a road, it is not just a stripe of land that is being removed from the same. The impacts of creating a road go way deep down into the forest, as it can be seen from the study of Pan American Highway, which is authority number 69 of the memorial, that the impacts of deforestation due to a creation of a road can go up to 30 kilometers. And Your Lordship, in the present situation, the whole wildlife sanctuary is merely of 40 square kilometers. Therefore, this becomes very important to be taken into consideration.
Are you trying to suggest that the road,
Road does
uh,
not pass through your
yeah, but the CWH, proposed CWH, the road doesn't pass through that,
pass
as
through the
my senior colleague has pointed out.
Indeed, Your Lordships and Your Ladyships,
So
the
the
Council.
tourist movement is also not really part of the CWH. So that's not going to affect your livelihood. You can still depend on the tourism industry.
Indeed, Your Lordships and Your Ladyships, the Council would like to uh, humbly submit that it is and has been trying to submit that it is not just a mere stripe of road. The impacts of the road are very deep, Your Lordships. It can go up to 30 kilometers, and it is therefore very important to take the same into consideration at least, which was not even done by the expert committee. Your Lordships, if it was only that a stripe of road would have removed, then it would not have been of such great importance. But the impacts of creating this road not only impact the wildlife and their movement, but can cause huge deforestation in a very wide area. If your lordships are
That is
through,
the
then
reason, Council. That is the reason the CWH doesn't permit coexistence as it presently stands. The proposed CWH.
indeed, your lordship, the council understands your lordship's concern towards the wildlife. And at the same time, the council would like to humbly submit that it is very important to take steps to ensure the preservation of the wildlife and the natural flora and fauna. But to that effect, we must not take any steps on arbitrary decisions, and we must take into consideration all the aspects and then take a decision which is best for the wildlife. And your lordships, various international organizations and even the country has accepted that the uh, cohabitation is one of the most important aspect and is the long-term solution to such issues. The same is also accepted as a fact under paragraph number 5 of the Moot proposition, your lordship. It is therefore very important to consider and choose the most viable option and not just any option, your lordships.
No,
Your
Mr.
lordship,
Council, in that contingency, it is for you accepting that the cohabitation is possible. Why did you not suggest any measures while you appear in that open discussion or in the Gram Sabha by a resolution of a Gram Sabha so that your species could have also been protected because this decline is since seen or been observed since last 5 years. So prior to this, probably the species thrived very well. So what is that which has led to its extinction or reduction? It is for you rather to explain it in an open discussion or the Gram Sabha to put it forth. You never gave any suggestions.
Indeed, Your Ladyship, the Council understands your concern, but to this effect, the Council would like to humbly submit that the community raised their points that they have been living peacefully with the wildlife for centuries. Similarly, Your Lordship, they even stated that their livelihood is dependent upon fish and minor forest produce, and also gave various other relevant points, but the same was not taken into consideration by the
Mr.
expert
Council,
committee.
Mr. Council, when the issue would come as regards balancing between your fundamental rights, as what you say, which is in fact not an absolute right, as it is a duty of the state to protect the environment, then in that case, what is the state expected to do? It followed the principles of natural justice. It afforded an opportunity to you for hearing. Open discussion, in fact, empowered you to put forward your points. So you did nothing. The state is duty bound to protect the environment and balance your fundamental rights, which are not absolute.
Indeed, Your
That
Ladyship.
is where the definition of CWH comes in.
Indeed, Your Lordships and Your Ladyships, the objections were made as a part of the procedure, but thereafter no action was taken by the community. These objections were neither taken into consideration, neither a reply to that was provided. The expert committee merely stressed on the harm, Your Ladyships and Your Lordships. Your Lordships, the council agree that they followed some procedure as per the statute, but that does not mean that the procedure that they followed was fair in itself. Even though they were given an opportunity, they were not given any reasons thereafter. Neither there was any substantial report provided to the petitioners in the present case. It is therefore these petitioners have approached this honorable court and are seeking justice from your lordships.
So why there is the expert committee report. It is that expert committee report which has been considered by the government, and then they have based their decision. You see,
Indeed, Your Lordships.
your submission suggests that something else could have been done, but that by itself is not a ground to strike down the declaration.
Indeed, Your Lordship, the council is humbly submitting before
Just continuing from what my senior colleague has said, what are the alternative recommendations that you have?
Your Lordships, the first recommendation that we have is that the government must must ensure cohabitation, and the second recommendation is that a special zone must be created with the help of indigenous and community people, which will be beneficial for both the community as well as the wildlife. Your Lordships. Your Lordships, coming to
Anyway, this is part of the protected area, and within this protected area, the CWHs ought to be created. So what is that other zone which you have in mind? That practical proposal, I mean, do you want a situation where they may have the modified rights, maybe where they can actually go in there and worship the banyan tree, come back maybe once a month? Something practical has to be suggested via media between what has happened and what you want.
Indeed, Your Lordship. Your Lordship, the zone that the council herein is talking about are known as indigenous and community reserved areas, also known as the ICCAs. Your Lordship, the council would firstly like to state that these provisions of the FRA, Section 5 specially, strengthens the creation of an ICCA. Your Lordships, as the Section 5A and D empowers and gives duties to the forest right holders to protect and save the wildlife and biodiversity, the same could be put into use and a special zone could be created, which is different from what is being proposed right now. Similarly, Your Lordship, the council would seek an extension of 2 minutes since the time's up and would like to summarize the arguments.
Yes, please go ahead.
Indeed, Your Lordship. Much obliged, Your Lordship. Your Lordship, the council would also like to state that this is not only a single instance where the government has given an option of cohabitation, but has understand and recognized the importance of community-led conservation. And to this effect, the government has itself created the forest policy of the year 1988, the National Biodiversity Action Plan, the National Environment Policy of 2006. The Lordships, all these policies by the government recognize that the loss of traditional rights has undermined wildlife conservation. And therefore, it is very important that the wildlife conservation is done with the help of indigenous people as being recommended by the petitioners herein. If your lordships are through, the council would like to move to issue 3 at hand.
Yes, please. Yes, please.
Much obliged, your lordships. Your lordships, issue 3 is what directions can the Honorable High Court issue in the present matter and to who? To this effect, your lordship, the council would firstly request this Honorable Court to issue a writ of mandamus. Much apologies, lordship. Much apologies, your lordship. Your lordship, the council would humbly request this Honorable Court to issue a writ of mandamus and ensure that the community is not moved out of their natural habitat or their livelihoods is not impacted. And to this effect, the court is not only empowered enough, but is actually duty bound, wherein the government or public authority has failed to exercise its discretion or has wrongly exercised the same. Your Lordship, it has been submitted at multiple points that the expert committee did not take into consideration all the relevant aspects. The procedure adopted by the committee was not just and fair. Secondly, Your Lordship, the counsel for the respondent would humbly pray for the formation of a new committee to reassess all such points because the same are of great importance for not only the right of the community but for the but to ensure that the wildlife is also protected, Your Lordships. Lastly, Your Lordships, the council would like to pray that the implementations of the recommendations so given by the petitioners is also done by the honorable governments. If your lordships are through, then the council would like to move to the prayer.
Yes, please. Yes, please.
Much obliged, your lordships. In the light of the issues raised, arguments advanced, reasons given, and authorities cited, this honorable court may be pleased to hold that the impunged declaration is invalid and unconstitutional as it violates the fundamental rights of the petitioners, issue a writ of mandamus against the government of Primrose and Gredor for the formation of a new committee, direct the government of the Primrose and Gredor to accept the recommendations for cohabitation as made by the petitioners, and direct the government of Primrose and Gredor to put a stay on the resettlement of the community, and or any other relief this honorable court may be pleased to pass in the interest of equity, justice, and good conscience, and for this act the petitioner shall forever be duty bound. Your Lordship, it was a pleasure arguing before this honorable court, and the petitioners would like to thank you for giving this opportunity to them.
Thank you. Thank you. Thank you very much. Yes. Yes, please.
Am I audible?
Yes, yes. Yes, please.
A very good evening to the Honorable Bench. The Council seeks permission to address the bench collectively as Your Honor.
Yes, please.
Much obliged, Your Honor. This is Council number 1, appearing along with Council number 2 on behalf of the respondents in the case of Nonita Chandan versus State of Primrose and others. Your Honor, the Council shall be taking for 17 minutes and shall be dealing with the issue number 1, whereas the Council number 2 shall be dealing with the issue number 2 and 3 and will take a total time of 13 minutes. Your Honor, if there are no preliminary queries pertaining to the facts, the Council would like to move forward with the issue number 1.
Yeah, you proceed with issue number 1 directly.
Much obliged, Your Honor. Your Honor, with regard to issue number 1, that is the declaration of the Moha critical wildlife habitat modifying the rights of the Mohia community is valid and reasonable. The Council shall be submitting the arguments in 2 prongs. Firstly, the Council shall be addressing that the declaration of the wildlife habitat is valid, and secondly, that the declaration is not arbitrary and is reasonable. Your Honor, coming to the first part, that the declaration of the Moha critical wildlife habitat is valid, the Council shall be submitting a twofold argument. Firstly, all the conditions which are essential under section 4(2) from clause A to F are met in the present situation. And secondly, the guidelines which are being issued by the central government in order to determine the critical wildlife habitat are also being adhered in the present matter. Your Honor, coming to the first fold, that is about the conditions, the Council would like to draw your attention to condition number 1, which is mentioned on section 4(2) clause A, which talks about the recognition and vesting of the rights to the Mohaya community. Your Honor, this condition has been duly fulfilled and it's been clearly given in the Moot proposition that accordingly the rights under section 3, A, C and D of the Forest Rights Act, the rights have been given to the Mohaya community. And the rest of the rights have not been given to the Mohaya community, which has already been approved by the Gram Sabha, and the Mohaya community didn't object to it. Your Honor, coming to the second condition, which is mentioned under section 4.2b, which that is that the activities, if the activities are of such a nature that they are sufficient in order to prove that they can cause an irreversible damage to the endangered species, then a critical wildlife habitat can be found.
Council, if I can
Yes, Your Honor.
intervene. Now, this community has been living in this area for centuries. Nowhere this problem arose. The problem has arisen only in the last 5 years. And that coincides with the road which you have built through this area. So why do you say that the problem has arisen on account of the activities of this community? And how could the expert committee report not even refer to the impact of the road on what has taken place?
Your Honor, for this, the council shall be submitting that why the scientific assessment which has been done by the expert committee should be taken in account. And for this, the council shall be given 3 reasons. Firstly, Your Honor, that the study is conducted by the expert committee under the guidelines. And that expert committee under the clause 5 of the guidelines consists of many scientists from various fields of science, ranging from botany, zoology, etc. That means they were competent enough to evaluate the situation. Secondly, Your Honor, that in the case of action research in community health versus state of Gujarat, the court admitted the satellite images which are being used by the expert committee as the scientific evidence. Your Honor, the nesting place of the little Mary lark has been destroyed because as the Mohaya community is collecting the shingle trees along with some other trees, along with some other leaves as mentioned on paragraph number 9 of the Moot proposition. Your Honor, now coming to the third reason why the scientific evidence is valid is that there are various scientific reports in international journals as well as in Indian journals which recognize that the scientific images are valid in order to determine the population of the endangered species. If that satisfies Your Honor's question, the council would like to move forward.
Mr. Council, was it not open for you for the expert committee? You could have directed the expert committee to carry out actual verification instead of relying upon the satellite images merely. Because the tribals who are actually dwelling in the village since the time immemorial, they have better knowledge because their specific version is this, that the specimens which have been shown by satellite images, that is not accurate to say that it poses a danger to this breeding of this particular species. So it could have been easy for you to carry out the physical verification instead of relying merely on satellite images.
Indeed, Your Honor. Your Honor, there has been an open consultation process, as mentioned on paragraph number 10, in which the forest dwellers were also a part of it. Your Honor, according to the condition 4E, which mentions that the Gram Sabha's approval and consent is also necessary in order to establish a critical wildlife habitat. And Your Honor, the council would like to draw your attention to the definition of Gram Sabha, which is mentioned under section 2G of the FRA.
Council, the words used are free informed consent. So there is a difference between a consent per se and an informed consent. What is the material to show that you have secured an informed consent? That the Gram Sabha was explained all the implications, given all the reports.
Your Honor, for this, if this court finds out that there's a difference between the consents, Your Honor, pertaining to the third issue in about the directions, this court can direct the Gram Sabha again to issue a report and to examine all the things that has been happened in order to determine and to establish a critical wildlife habitat.
But we'll have to strike down the declaration. We'll have to strike down the declaration and say that this exercise should be undertaken all over again.
Your Honor, could you please repeat your question? I was not able to hear you.
See, in that case, we'll have to strike down the declaration as critical habitat CWH, and then we'll have to refer the matter to the Gram Sabha to once again consider the issue. Are you agreeable for that?
Your Honor, the council is saying pertaining to the expert committee's report, if there is any discrepancy in that report, then Your Honor can direct the Gram Sabha to again to guide and to initiate the process with the Mohia community to determine whether the critical wildlife habitat is right or not.
Council,
Your Honor, yes, you have to
Council,
give a stay on this particular order.
Council,
My brother wants to, yes.
Yes, Your Honor. Yes, Your Honor.
What's being said is that we will have to strike down the notification and the whole process will have to start again. So instead of that, if you can show whether all this was disclosed and they were explained, and that also includes the scientific data and the objective criteria that you have relied on before passing this notification. So that you should bring out. What is that criteria? Not just to say that the nesting place was not available because they were collecting the leaves. It's not sufficient. There has to be something scientific. You had zoologists and such life science experts there. So there has to be something objective also about the whole process. So that is what is being, that's what we are trying to understand.
Your Honor, for that, the council has previously stated a case in which the satellite images were being taken valid as part of scientific evidence.
But what is that criteria? See, first you have to have the criteria and then you have to work on the evidence. So what is that criteria which you are considering before you declare anything to be a CWH? And that must be disclosed to the population in the open consultative process. And that your report or your expert committee should bring out very clearly.
Absolutely, Your Honor. According to the guidelines, Your Honor, when there's a public notice, all these conditions are being translated and are being communicated to the forest dwellers. It's been mentioned on guideline number 7.3 that all the necessary things which are essential in order to establish the critical...
It says 7.3 Roman 2, scientific and objective criteria adopted in identification of critical. So what is that you have adopted or you're expected? Have you disclosed that to the forest dwellers?
Your Honor, that is being disclosed to the forest dwellers because there isn't any lapse of procedure by the side of state, and the petitioners haven't alleged that there was some procedural lapse. They are against the idea of their idea of livelihood opportunities that is being curtailed by the modification of the critical wildlife habitat per se.
Because that is their fundamental right to earn a livelihood. Therefore, they are saying that their fundamental right is violated. So
Indeed,
when there is an infringement of fundamental right, the burden is upon you to justify. Either by means of, you say it is in form of reasonable restrictions. That's the only way how fundamental rights can be curtailed.
Indeed, Your Honor. Indeed, Your Honor. The council shall be addressing your concern about the right to livelihood and the other rights which are not being violated by the creation of the critical wildlife habitat. Your Honor,
what is your straight answer? What is your straight answer to this? Come straight to the point.
Indeed,
how do
Your
you
Honor.
justify the violation of Article 19(1)(g) or for that matter 21?
Your Honor, the council is well aware of the fact that Article 21 covers the ambit of right to livelihood. But Your Honor, in that particular judgment in which the ambit of Article 21 was widened, the Olga Tellis judgment, the court also said that it is the state is not compelled to give the right livelihood opportunities to its citizens. Apart from that, Your Honor,
here you are taking away their opportunities which they have had for centuries.
I mean, memorial.
Yes.
Indeed, Your Honor, the council would like to point out that the Article 21 also established that if the procedure established by law is followed, the right could be put to certain reasonable restriction. And that has been done in this present case, Your Honor. That particular right to livelihood, if it in case is affected, a resettlement package or an alternate package is designed in a way so that the livelihood opportunities are not affected as per the condition which has been mentioned under section 4(2) of the Forest Rights Act, Your Honor. If that answers your Honor's query, the council would like to...
So according to you, if compensation is afforded, then you can denude them of their rights absolutely.
Your
Is it
Honor,
your submission?
Your Honor, they haven't been provided with the compensation. They are being provided with the rehabilitation and the resettlement packages, completely settlement packages to them.
So
And also the
outside the
settlement packages, Your Honor,
outside the forest area.
not your outside the forest area, Your Honor. They can be settled in the part which is not falling under the critical wildlife habitat. They can be settled in that particular area as well. Your
Yes.
Honor, if that answers your query, the council would like to move forward.
Yes, please.
Your Honor, the council has already been trying to already establish that all the guidelines and all the conditions which are mentioned under section 4.2 have been met in this particular matter. Now, coming to the second part of the council's submission, which mentions about the rights, as the council already addressed about the right to livelihood, the council would like to throw some light on the other community rights which the petitioners are alleging that are being violated in this particular case. Your Honor, under FRA, Section 3, the rights which are being granted to the forest dwellers are mentioned under Clause A, C, and D. And the religious right and the other customary rights, the main contention of the petitioner is that which are being violated are mentioned under Clause K and L of the FRA under Section 3, Your Honor. And those rights are not being granted to the forest dwellers.
Are you suggesting that you are willing to modify your notification to that extent?
Yes, Your Honor, because the modification is being done to the extent that their right to only pertain to their livelihood opportunities. Your Honor, addressing your concern, the council would first likely to draw your attention to the point that this there's a case, Odisha Mining Corporation case, in which the Honorable Court said that these customary rights which are being given to the forest dwellers are to be decided by the Gram Sabha and not the Honorable High Court, Your Honor. So, in order to determine their rights, which the process is already been taken place by the Gram Sabha, as it's been mentioned under the Moot proposition. And Your Honor, as per the definition which is mentioned under Section 2B of the FRA, which mentions about the critical wildlife habitat, it uses the term inviolate. Your Honor, the term inviolate per se doesn't mean there cannot be any human intervention in the critical wildlife habitat. Your Honor, excluding their livelihood opportunities, they can still come to that place and worship the banyan tree.
But your declaration does not say so. Your declaration virtually says that it will be a CWH, which means it will be inviolate. They won't even be able to enter there to worship their banyan tree, which they have been doing for all these years.
Indeed, Your
And
Honor.
apart from Section 3, what about their rights under Article 29 of the Constitution?
Your Honor, the rights in the Article 29 are being given to the scheduled tribes, and the concerned party in this particular matter are the forest dwellers. So they aren't a part of Article 29. They don't fall under its ambit.
You're in one way suggesting that they can come and worship the banyan tree, and to that extent, if the government modifies the declaration, that should be all right.
Indeed, Your Honor. Because, Your Honor, the livelihood that the Mohia community professes in the critical wildlife habitat is the main reason why the species are being endangered.
We still don't have an answer that why this endangering of the species did not take place for all these years, but started only for the last 5 years. So why should we not say that this has a nexus with the road which you have constructed in the area? And why is this important aspect not even looked into by the expert committee?
Your Honor,
does this not attract the Wednesbury principle of unreasonableness?
Your Honor, the road can also be built in a wildlife sanctuary. It's been mentioned under FRA if all the procedure is duly complied with. And the Moot proposition is silent whether the road that was built didn't comply with the provisions of the FRA. And also, Your Honor, the critical wildlife habitat which is being made under the wildlife sanctuary is of such a nature that the animals which are being found are in majority being found in that particular area. That's why the expert committee made a distinction between the rest of the sanctuary and the critical wildlife sanctuary. Your Honor, the Council now would like to come to the second aspect, that the declaration is not arbitrary in nature. Your Honor, the Council would like to throw some light that the IUCN reports, there are various IUCN reports which shows that the antelope has been endangered, and these steps have been taken in order to improve the population of the endangered animals. It is not an it is not a step which is taken in a haste. Your Honor, the Council would also like to draw your attention to the footnote number 69 in our written submission, in which we have cited a report of the Ministry of Tribal Affairs, which is being done in consultation with Ministry of Environment. Your Honor, this report mentions about the critical wildlife habitat and how the critical wildlife habitat will be formed and many other aspects to critical wildlife habitat. Your Honor, this report was published in the year
This is the
2017.
council, but all the material which you have considered does not say that the Mohia community has anything to do with the threatened extinction of the Oliver antelope. Still, why should you modify their rights insofar as this area is concerned?
Your Honor, as per Moot proposition paragraph number 9, it mentions that the activities of the Mohia community are affecting the growth and the population of Oliver antelope. And it's also been mentioned that these activities are near the river. Your Honor, the river is also part of the critical wildlife habitat.
So the river runs through, Mr. Council, the river runs through the entire Mohia Wildlife Sanctuary. It is not limited only to this critical wildlife habitat. It runs through the entire Mohia Sanctuary, and there are 8 villages which are situated alongside the fringes of the river, which runs through the entire sanctuary. So what is the purpose in restricting it only to this particular area? Because as far as antelope is concerned, you are attributing it because of the excessive use of this this particular community on the fringes of the river.
Your Honor, the majority of the species of the which are being that is Mary lark and the Oliver antelope are found in the critical wildlife habitat. That is one of the main reasons why a particular segment of the wildlife sanctuary is being demarcated into wildlife critical part and the rest of the part.
Isn't there a provision where you have a limitation on time, that this will be a CWH for, let's say, a period of 10 years till when the habitat regenerates itself into numbers which are expected? Is there some such provision, or can you look at something like that?
Your Honor, there isn't any provision mentioning that it will be a short-term process to make a critical wildlife habitat.
Yeah, because that is something that also needs to be considered when you want to when you're considering what modifications can be made to the order or what you would permit the court to do.
Your Honor, I absolutely understand your concern, but once the critical wildlife habitat has been made, it can't be turned back into a normal habitat, because it's mentioned in FRA that a critical wildlife habitat is made is like a long-term solution for the population and for take into consideration about many factors which are to be taken in account.
Then therefore the questions which were raised by the petitioners, that what about coexistence? You see, tribals and people, forest dwellers, they coexist with nature in such areas. You can't just remove one from the other. And even when you see the example of what is happening in Andaman and Nicobar, the people are still there. It's not that the people are being removed or taken away. So there has to be some restriction or some limitation on time. Okay, when the regeneration has taken place, when the habitat has been sufficiently protected, then they can be brought back. They can be allowed to come and what shall I say, reorient themselves to the original habitat.
Absolutely, Your Honor. As I can see that my time is up. If I can be granted with an extension of 1 minute to
Yes.
sum up my argument.
Yes. Yes.
Your Honor, the condition of the coexistence, which is also essential in order to establish a critical wildlife habitat, will be dealt by my co-counsel, because it is not recommended by the state that it is a viable option in this particular matter. And Your Honor, secondly, the council would like to draw your attention to the point that after the regeneration, the purpose of the FRA is the upliftment and the betterment of the forest dwellers. If they move out from that particular critical wildlife habitat, it will also facilitate them in order to improve their conditions as well. That's why it could be one of the reasons that if a critical wildlife habitat has been made, it would also be difficult for the forest dwellers to rehabilitate in that particular critical wildlife habitat.
No, that may not happen, because they are part of their entire habitat. Now they are being removed from there and sent somewhere else for resettlement. So I don't think it will be difficult. In fact, it will be more natural for them to be rehabilitated there.
Indeed, Your Honor. Indeed, Your Honor, I absolutely understand your concern, but bringing them back to a primitive age is not the purpose of the FRA. It would
That
be
all
for their
depends on-
betterment, Your Honor.
That all depends on what you think is development.
Your Honor, because under one of the conditions, we are providing them with the livelihood opportunities. We aren't affecting them with any of their livelihood opportunities.
No, but that's the whole
Mr.
point.
Counsel,
Your Honor, divine within constructive approach.
The whole purpose of FRA is recognition of their rights, of their vested rights, and vested rights as traditional forest dwellers. That is what the Act aims at. And this is creating of this habitat is a provision under the enactment. So
Indeed,
it will
Your Honor.
always stand
Indeed, Your
subsidiary
Honor.
to the rights which the Act aims to protect.
Indeed, Your Honor. But in the Act also mentions about the modification. Your Honor, if the aspect of modification has been mentioned in the Act.
Modification to an extent that you do not denude them of the whole purpose and the aim of the enactment, because it was protection of their traditional rights as forest dwellers.
Indeed,
That
Your
you
Honor.
are forgetting, completely missing out.
Indeed, Your Honor. The modification, Your Honor, has been done to the extent of their only livelihood opportunities, because their livelihood opportunities are majorly in the part of the critical wildlife habitat. And that is the main concern of the state. That's why they had to modify their rights only to the extent of livelihood.
Livelihood also, as regards only these particular trees are concerned.
Your Honor, according to paragraph number 9, they also collect other minor forest produce along with the shingle trees, along with the shingle tree leaves.
But that will cause no harm to the endangered species specifically.
Indeed, Your Honor, but majorly the shingle leaves are causing harm, and their activities near the river bank.
See, I
So
think
according to you, they have to completely remove themselves from this area.
Your Honor, completely from the critical wildlife habitat.
Yes.
All right.
you should take a look at the preamble to this to the FRA. It says
Indeed,
an
Your Honor.
act to recognize
Traditional rights.
yes, and other traditional forest dwellers of other traditional forests who have been residing in such forests for generations. So they have been residing there for generations. You see, you can't just
And that act presupposes coexistence.
Yes.
Absolutely.
Indeed, Your Honor. The co-counsel shall be dealing with the issue of coexistence in depth. As I can
All
see
right,
that
then
I
we would like to hear your co-counsel at this stage.
Yes.
Indeed, Your Honor. It was a pleasure arguing before this honorable
Thank
High
you
Court.
very much.
Thank you.
Thank you very much.
Shall I start?
Yes. Yes, please.
A very good evening to the Honorable Bench. This is Council number 2 on behalf of the respondent. In our submission today, we shall be addressing the issues pertaining to, first, the integration of Mohaya community with the Moha critical wildlife habitat, and second, directions that can be issued by the Honorable High Court. With respect to the issue on integration of Mohaya community, it is our submission that alternative of peaceful coexistence is not feasible in light of the depleting environmental conditions in the proposed CWH. Your Honor, the petitioners
Madam,
have
do we ask you to reply to the questions on which we had left your first speaker as to the considering the objects, just as Ahuja had read to you the object and the preamble of
Indeed.
the FRA, and this is something creation of this wildlife habitat is a part of this enactment.
Indeed,
So we
Your
would like
Ladyship.
to know from you as to how it would achieve the purpose of the enactment.
The creation of the critical wildlife habitat?
Yes,
Uh,
excluding their traditional rights as forest dwellers, which was the aim of the act, and under the FRA they were granted this protection. But while creating this critical wildlife habitat, you are denuding them of this particular protection.
Your Ladyship, the rights granted under FRA are not absolute in nature. And in fact, the FRA itself provides for the creation of CWH. The creation of the CWH concomitantly involves the modification of their rights. We are not divesting them completely of their right. Moreover, the proposed CWH covers less than 35% of the entire Moha Wildlife Sanctuary, leaving behind an entirety of more than 60% for the benefit, use, and existence of these forest dwelling communities. Therefore, we insist that the modification of the rights is in consonance with the objective of this act, and it does not go against the spirit of FRA. Your Honor, Your Honor, moving further with my arguments, the petitioners have willfully overlooked the fact that peaceful coexistence as an alternative was already perused by the respondents. And it was after such perusal that the respondents came to the conclusion that this would not be a feasible alternative. It was after all the conditions under the act were fulfilled and the consent of Gram Sabha was obtained that the respondents went ahead with the declaration of the CWH. Granting the alternative of coexistence at this stage will not only cause irreversible damage to the endangered species, or in fact the critically endangered species, but will also go against the ethos of the precautionary principle. Your Honor, it is no longer res integra that precautionary principle forms a part of the Indian environmental law policy. In fact, the Supreme Court in the case of Vellore Citizen Welfare Forum versus Union of India reiterated this and also put forth two obligations on the state. And I quote, the obligation to anticipate and prevent the cause of environmental degradation. And second, the obligation to avoid postponing remedial measures due to lack of scientific certainty when there are threats of serious and irreversible damage. Your Honor, the court has time and again observed that it is better to err on the side of caution and prevent the consequent environmental harm rather than run the risk of irreversible damage. The precautionary principle suggests wherever there is an identifiable risk of serious or irreversible harm, as in our case, the extinction of the critically endangered species, the Oliver antelope and the Mary lark, the presumption should always fall in the favor of environmental protection. For your reference, Your Honor, page number 15, footnote number 103 of the memorial, the precautionary principle is premised on the fact that a false prediction of human activity doing no harm to the environment is any day more harmful than a false prediction of it doing significant damage. Hence, uncertainty of scientific evidence cannot be a hindrance to environmental protection measure. Moreover, the same has been reiterated by various international conventions. The petitioners relied on the Convention of Biological Diversity, and that convention itself in its preamble states the importance of the precautionary principle. In our instant case, the activities of Mohaya community have led to a steep decline in the number of shingle trees that are the nesting place of the endangered Mary lark. I must emphasize at this point that these species are critically endangered, and the IUCN defines critically endangered species as such species that have an extremely high chance of extinction. The reason behind declaring the CWH is to check this alarming decline in the number of the endangered species and also the decline in the number of the shingle trees, the collection of whose leaves have these forest dwellers been thriving on. It is all, moreover, Your Honor, it is settled that the state is vested with the duty to preserve the forest. In fact, the Guwahati High Court, in the case of Mrinal Sakia versus State of Assam, categorically held that in order to protect wildlife, if the forest dwellers have to be evicted with appropriate compensation, that would be legal and would be and that would be in lines of Article 48A of the Indian Constitution. We again submit that allowing coexistence at this stage will be inimical to the preservation of the natural habitat. In fact, in the case of Pradeep Krishan versus Union of India, the Apex Court pointed out that the total forest cover in India had gone below the ideal minimum of 1/3 of the total land. And therefore, the Supreme Court warned against any further shrinkage in the forest cover. And it also noted that if
we agree with you.
Yes,
That the
yes,
forest cover has to be protected and that it is being critically endangered.
yes.
But the question is it right to lay the blame at these forest dwellers? Because for all this while, the forest was all right. I mean, these species were not endangered. It is only after the road that the problem has started. And that road is not the creation of this community.
And tourism also.
Indeed, Your Honor. I absolutely understand your concern.
Have you considered the option of closing down the road? Have you considered the option of not having any tourism in this entire area of 40 square kilometers?
Your Honor, the MWS, as you rightly pointed out, covers 40 square kilometer and the CWH is only 15 kilometers square in area. And that is specifically because in this area, the population of the shingle tree has gone down and not in the remaining area. Moreover, we have to look at it through the lens of environmental protection. When we are looking at the CWH, we have to take into consideration that it is not only the tribals whose rights are being affected, but also the government who won't be allowed to develop any project there, even the tourism industries, even the tourists who will not be allowed to enter that CWH. So if we look at it through the lens of environmental protection, we see this as a positive step and not as a negative step. This is a step which affects everyone equally. And there is no distinction that has been made by the government that would adversely impact the tribal people.
Madam, it is quite possible that as far as these two particular species are concerned, you say that this is the particular critical area where they are endangered and the tribals are mostly located. Tomorrow, it may be possible that for some other species, you may say that we will carve out some other area as the critical wildlife habitat and thereby denuding them for the entire forest. The forest, because they are the forest dwellers. You are right in saying that whenever it has a proposition comes that they have to be at necessary, they'll have to be evicted. But these are recognition of the rights of forest dwellers who the state government was quite aware that they are thriving on this forest produce for years together. So tomorrow, if you for another species, if you demarcate some other area, 15 square kilometer, then 15, that's why how you will completely oust them out of the entire forest area.
Precisely, Your Honor. I absolutely agree with your point that the forest dwellers have traditionally been dependent on the livelihood from the lazy river. However, that is exactly why we have come up with the alternative package. Our recommendation includes the alternative livelihood opportunities for these forest dwellers. Moreover, with regards to your concern,
what opportunities do you propose, madam? What opportunities do you have in your mind?
Your ladyship, we among other options that we have, we also have included the inclusion of the inclusion of the forest dwellers within the tourism industry, and the revenue collected out of the tourism industry will go to the welfare of the tribal beings. Moreover, we have also suggested to promote tribal art and tribal craft so that they also earn something independently and self independently, your ladyship.
But you will have to imbibe the skills into them for this purpose.
Indeed,
You will have to undertake.
ladyship.
Does your government have any program in hand at present?
This is what we will be recommending in our issue 3, your ladyship, and I will address that shortly.
All right.
In the view of the probable...
Just one more thing, I'm sorry, connected
Yes,
to
yes, Your Honor.
a senior colleague has said. Are you not considering training these forest dwellers to live in harmony with the CWH so that they can be reintegrated there after some time? Today, there has been a loss of these wild species. But if they are reintegrated after proper training as to why these species need to be protected, that would be a long-term effort rather than trying to separate them, send them off somewhere and again training them into some other skill development.
Indeed, Your Lordship. This is something that the subdivisional level committee can also look into, and this could be subsequently modified by, again, open consultation with the Gram Sabha. However, we still persist that the alternative of peaceful coexistence is not viable. In fact, in view of the probable ecological imbalance, human overpopulation, and depletion of sources, this alternative is only an illusory idea that cannot be translated into reality, at least in the 5 to 10 years in the near future. In this conspectus, we instead recommend that the community accept the comprehensive resettlement package as put forward by the respondent. Among other things, the resettlement package includes monetary compensation, provides for an inclusive tourism in the MWS, wherein a share of revenue obtained from the tourism industry shall be used for the welfare of the community. And the package also emphasizes the tribal art and craft as a means of livelihood for the community. Unless Your Honor have any other question, I shall now move to my next issue.
Yes.
Much obliged, Your Lordship. With regard to the third issue on direction, we submit that Article 48A puts the duty on the state to endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. Therefore, we request the court to issue directions to the nodal agency under the FRA Act for the proper implementation of the resettlement packages as per Section 4.2D of the FRA. Moreover, we also request
the government.
There is no need for direction.
Yes, correct.
That is, you are statutorily bound to do that.
Yes.
Indeed,
you are the respondent. You are supposed to do that.
Yes.
Indeed,
And it is
Your
their
Honor.
PIR and not yours.
Yes.
Indeed, Your Honor. We only request for a recommendation on part of Your Honor so that the tribal community are more welcome and more open to accept the alternative recommendation package. We also request the High Court to invoke the doctrine of parens patriae and grant forests the status of legal personhood. In that regard, I would like to cite the example of El Salvador.
For that, you may have to file a separate suit or petition for a declaration or something.
No, you are the mighty state. It is up to you. It is up to you to apply all this.
It is only when the state fails that we have to assume the parens patriae jurisdiction. So is this a concession that you have failed?
No, Your Lordship. We only request for a recommendation so that the executive and the authorities are put into action more expeditiously than they have.
It is up to you to move your authorities, madam. It is up to you to move your authorities, how swiftly and smoothly you can ensure that.
Completely agree with you, madam. Completely agree with you.
Yes.
With this, I would like to rest my submission unless Your Honor has any other query. And now I would like to move to my prayer.
Yes. Yes.
Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the Honorable Court may be pleased to hold that the declaration of the Moha critical wildlife habitat is valid and reasonable, hold that the integration of Mohaya community with the Moha critical wildlife is not recommendable, and direct the and also hold that the resettlement package be accepted by the Moha community.
Madam,
Thank
your
you.
prayer should be simply dismiss their petition. That's it. Nothing more than that. You don't have to ask for anything. You have to only pray that the petition should be dismissed with cost. Yes, thank you.
Pass any other order in the if that the court may deem fit in the light of justice, equity, and good conscience, all of which is humbly prayed. Thank you. It was a pleasure arguing before the court.
Thank you very much. Thank you. Thank you very much.
Yes, 2 minutes for rebuttal. Team G.
Much obliged, Your Ladyship. Speaker number 2 would be doing the rebuttal, and the council would strictly stick to the points raised by the respondents in their oral arguments. Firstly, Your Ladyships and Your
They
Lordships, the
have
council.
given you, they have offered you a concession saying that as far as your banyan tree is concerned, you can visit that area for the purposes of offering your prayers. So your Article 25 is not violated. That's a
Then your
concession which they have given.
Then, Your Lordships, the respondents herein have violated the whole purpose of this special zone that is being created. That is, it has to be kept inviolate, and they have themselves considered that whatever the petitioners want can happen in there. Beginning with the rebuttal, Your Lordships, the council would like to firstly submit that satellites are not wholly reliable, as has been held by the Honorable Supreme Court in the case of INRE construction of park at Okla Bird Sanctuary in the year 2011, as it cannot show the actual position. Similarly, Your Lordships, the council would like to submit that the reduction was because of the reduction of the trees. The reduction of the endangered species was because of the reduction of trees. And it has been accepted that the community does not take any sorts of timber from the forest and merely relies on the minor forest produce. Secondly, Your Lordships, the council would like to state that the learned counsel for the respondents herein have stated that the right under Article 29 applies only to SCs and STs, which is not true as per law, and it applies to any section of the citizens having a distinct culture. Thirdly, Your Lordship, cohabitation was not considered is clearly stated under paragraph number 12 of the Moot proposition. Your Lordships, the council would also like to submit that lack of scientific evidence is very different from acting completely under a belief. Your Lordships, under paragraph 9 of the Moot proposition, it is stated that the expert committee believed that the actions of the community are responsible. They do not have any scientific evidence at all with regards to the same. Therefore, the council humbly states that it is very different from having lack of scientific evidence, and therefore the same must not be taken into consideration as pleaded by the learned respondents. Lastly, Your Lordships, the council would like to say that the learned respondents have misrepresented a few facts as well, as there are no facts to suggest that the animals are found only in that particular area, and therefore the same is misleading this honorable court. Similarly, the facts are silent as to what all is being provided under the resettlement package. With this, the council would rest the arguments and thank this honorable court to grant an opportunity to plead before. It was indeed a pleasure arguing before this court.
Thank you.
Thank you. Yes. No surrebuttal, no surrebuttal, Mahesh.
Unless they want to say something, we'll allow them.
I would take only one. I would only take 1 minute. Yeah. The counsel from the petitioner's side has said that satellite imagery as scientific evidence is not admissible. However, the Gujarat High Court in Action, Research and Common Health and Development versus State of Gujarat categorically accepted and relied on the satellite imagery as a piece of evidence. Moreover, the council also spoke about the scientific and objective criteria of the report. However, we would like to cite that the expert committee's report had taken everything into consideration. Moreover, this expert committee is formed of the constituent of this expert committee, among other people, include one social scientist, two expert on life sciences, ecology, zoology, botany, wildlife science. Therefore, all these experts had given proper studies and had poured through the required aspects before coming up with the declaration of CWH. Thank you.
Yes.
Thank you. Thank you very much. So can we request the organizers
that was an absolutely fine display of advocacy skills on part of our finalists. The petitioner Team G, represents Symbiosis Law School, Noida, and the respondents, Team F, represent National Law Institute, University, Bhopal.
Indeed, that was a great final round. And we will now proceed with the valedictory ceremony for this evening. To begin with, we would like to thank Dr. Rohidas Kale, the principal of Government Law College, Mumbai. He has always been a pillar of strength for the Moot Court Association and has constantly encouraged and supported us. So for the same, we would like to thank Mr. Kale for everything.
We also have in our midst Dr. Anish Andheria, a Carl Zeiss Conservation Awardee. He is a fellow of LEAD and the president of the Wildlife Conservation Trust. He is a member of the steering committee of Maharashtra and Madhya Pradesh State Boards of Wildlife and the Madhya Pradesh State Tiger Conservation Foundation Society. Apart from being a firebrand conservationist, Dr. Andheria is also a reputed wildlife photographer, author, communicator, and motivational speaker. We would now request Mr. Andheria to address the audience.
Hi, everybody. Hopefully, I am audible. Benaisha, am I audible?
Yes, sir.
First and foremost, I must take this opportunity to thank Justice G.S. Patel, Honorary Justice Abhay Ahuja, Honorary Justice M.S. Sonak, Honorary Justice Bharti Dangre for supporting this activity and for encouraging the students all through. Unfortunately, I was traveling for the last 2 days and I couldn't be part of the discussions earlier. However, I got glimpses of the event in the last 1 hour that I was quietly observing, and I really liked the kind of arguments that were put forth by the counsels on both sides. They were very eloquent, and I must also applaud the patience with the honorable justices were encouraging the students. And I feel if these students go ahead and start working in the field of environment and conservation, I think India will go a very long way in protecting the unsung heroes, which is the forest staff, and also the ecosystems, which is fueling businesses all across this planet. So I once again thank everybody who have made this possible. Obviously, the Moot Court Association needs a special mention, and this is the Moot Court Association of the Government Law College in Mumbai. I must also thank our partners, Initiative of Climate Action, and all those who have made the earlier rounds possible. As I mentioned, I was not part of those rounds, but I got constant feedback from my team, headed by Samyukta and Anukruti, who have made this happen. So I must thank everybody once again for their wholehearted contributions. FRA, when you talk to conservationists, you will generally feel and you will hear that people on the side of wildlife find and they believe that they have been shortchanged by the enactment of FRA. However, people who have worked in the field of conservation for 3, 4, 5 decades, they are witness to the injustice that was doled out to communities when the tiger reserves were formed. As you all know, the Wildlife Protection Act was enacted in 1972. Then came the Forest Conservation Act in 1980. Before that, hunting was prevalent across the country. If you go back in time, just when the British came into the country, they brought with them sport hunting. And at that point, huge numbers of large carnivores, elephants, rhinos, wild buffaloes, all the big game that they were used to hunting in Africa, they brought that sport into India. With them, they brought in a lot of guns, ammunitions, and vehicles. So with ammunitions and technology, which means vehicles, and the thousands of beaters that the villagers that they used to use, they massacred wildlife in very, very large numbers. They also thinned the forest in a big way because a lot of wood that they needed to lay railway tracks across the territories that they held, they needed that supply. So a lot of wood from climax forests was taken out. Selective felling happened. Teak, that is Tectona grandis, and Sal, that is Shoria robusta, were taken. A lot of forest was converted into plantations. And so they ruled for 200 years. And during that period, a lot of our big wildlife vanished. A lot of forest was still there, but it started becoming patchy. Once they left their legacy behind. They left a lot of arms and ammunitions with the Maharajas, with local populations. And after their exit, people started hunting wildlife. And between the late 40s and early 70s, and I speak not from my own experience, but from other conservationists who were working during that period. Conservation, the term was not coined as yet, but people who were interested in wildlife, they do talk about those days when they walked in some of the prime habitats, like Nagarhole, like Kana, and for 10 kilometers that they walked, they hardly saw a single deer there. So from then on, because of the Wildlife Protection Act and the Forest Conservation Act, India became the world leader in protecting large game, and also in the name of tiger, a lot of other terrestrial ecosystems and also river systems. Most people who are here may not know that nearly 600 rivers originate from forests that hold tigers. So tiger conservation and conservation of terrestrial ecosystems is conservation of water. And India is 1.35 billion people, of which 65% are farmers, and therefore they are dependent directly on surface water. And so the forest, which is the birthplace of rivers, is indirectly supporting nearly 65% of Indian population. Another 30% are dependent on fisheries, either freshwater or along the coast, which is marine fisheries. And I would just add a sentence here that without rivers, which are without the fresh water coming into the sea, you will not have the kind of fisheries in the ocean that you enjoy today. And a lot of the marginalized fishermen don't have the technology, so they go in small boats and therefore they can't go far away, and therefore they are dependent on all the rich fishing zones that are created where the river meets the sea. So the forest was protected in the name of the tiger. A lot of protected areas were declared during that time. At that very moment, obviously earlier, the people were pushed into trucks and thrown out of the forest because some areas had to be protected. And those people were in fact relocated once more. So they were relocated for the dams, they were relocated for creating protected areas. And now, so there was a small population of people who were shortchanged because of the larger common good. So definitely in earlier era, it was all human dominated, wildlife was massacred. After 1972, the pendulum swung towards the forests, and at that point, people got shortchanged. And so this pendulum has been swinging. So with the FRA, there is an opportunity to equalize this. And currently what you see is basically a tug of war between the communities who are trying to survive because they are still subsisting. Just some figures, 3 million people live inside India's 50 tiger reserves. 100 million people are dependent on these 50 tiger reserves. The area of these 50 tiger reserves is just 2.4% of India. Another 2.5% of India comes under protected area network. So you have around 650 to 660 national parks and sanctuaries, plus some community and conservation reserves. All of it put together is about 5% of India. So today, as I talk to you, 95% of India is multiple use area, which means an area where human beings and wildlife, especially in the forested areas, which are outside protected areas, they live together. Most of the urbanized areas, there is no wildlife. So the only hope for wildlife is this last 5% that is left because of the protected area network. Of that also, nearly 80% is national park and sanctuary, 20% is community and conservation reserve, which means there communities are protecting the forest. So with FRA, what has happened is the genuine concern of the people was addressed. However, human beings are greedy, whether they are living in Bombay or they are living in remote areas, especially people who live in very, very marginalized conditions, have to compete with each other. And therefore, what has happened is after the enactment of the act, because the cutoff date was very was not fixed, a lot of land has been grabbed post FRA declaration by those miscreants. This is not the larger population, it is some section of the communities who have gone in and clear felled the forest and declared that forest as something that they were using even before FRA was launched. And so that a huge amount of this 5% of forests has been grabbed. And that is the biggest challenge now, because India, as you know, is under severe water crisis. Remember, water crisis, when I say, you're talking about the marginalized communities, because out of 65% of Indian population, that is farmers, out of all farmers, 85% are marginalized, which means they have less than 1 hectare or less than 2 hectares of land. And so, as I was listening to the students, I was encouraged that they were seeking for a balance. They were talking about critical wildlife habitat, which is part of the FRA. The FRA has actually made that happen. And it's now important that the pendulum finally rests in the middle, which means development, livelihoods of the people, and the welfare of wild animals can go hand in hand. So through the FRA and the Wildlife Protection Act, I think we have a mechanism in the country that can stabilize the landscape. So this, I must say, again, congratulations to all the students who have been participating. There are at least I think there were 16 colleges that participated. Again, it sounds cliched, but everybody who participated is actually a winner. We will have to give out the winner, the first and the second, but I think participating in something like this and a cause which is larger than life, because protection of forests is extremely vital for the survival of the unborn generations. It has direct implications on climate change. And so I thank everybody, all the honorable justices who have been part of this, to have made this a successful event. And I'm hopeful that with the help of the Government Law College of Mumbai, Wildlife Conservation Trust will be able to run this moot court for many, many more years and decades to come. Thank you all, and all the best to everybody. Thanks.
Thank you so much, sir. We also have with us Mrs. Anukriti Upadhyay, who has postgraduate degrees in literature and management and a graduate degree in law. She also wrote a doctoral thesis on human relationships in postmodern Hindi stories in a past life. She writes fiction and poetry in both Hindi as well as English. Mrs. Anukriti has previously worked for Goldman Sachs and UBS in Hong Kong and India in various senior legal and compliance positions. Currently, she works with the Wildlife Conservation Trust. We now request you to address the audience.
Thank you very much. The special invitee for this session, Honorable Mr. Justice G.S. Patel, Judge for the Bombay High Court, Honorable Justices Srimati Bharti Dongre, Mr. Justice Abhay Ahuja, Mr. Justice M.S. Sonak, the GLC team, my colleagues at Wildlife Conservation Trust, Dr. Anish Andheria, and the GLC principal and professors who've supported this, this event. I congratulate all of you on the successful completion of the second edition of the Wildlife Moot Court. It's one of a kind in India, the only moot court focused on environmental issues. It was wonderful to see the engagement of the young lawyers. It was very, very interesting to see how they came up with arguments for and against, trying to strike the right balance, as Anish said, between the needs of the forest dwellers, their rights, their generational rights over forests, as well as the rights of the animals and the preservation, the conservation rights for the forest itself as an entity. So it was extremely invigorating and stimulating to watch that, the final session of the moot court. I'm sure the other sessions, the preliminary sessions, were as interesting. I hope that the crucial topic of conservation now being brought forth through this moot court will encourage more young lawyers, more professionals in the legal profession to come forth and advocate for and fight for the cause of conservation in the courtrooms, where a number of these important battles are going to be waged now. So with that, I welcome all of you for the valedictory session, and may the best team win.
We also have with us Mr. Jay Warrior on behalf of our knowledge partner, Initiative for Climate Action. He holds a sociology degree from Durham University and is an environmental sustainability enthusiast who aims to transform all businesses and communities to be more sustainable. His passions include nature, photography, and travel, and his main reason to tackle the harmful effects of climate change is to preserve the planet's natural biodiversity for future generations to enjoy. We request Mr. Jay to address the audience now.
Yeah, thank you, and good evening, everyone. It's a pleasure to be here. I hope everyone is doing well and safe wherever they are. It's great to address everyone today. I'd like to start off by thanking all the honorable justices for making time and sharing their experience with the future generations of lawyers and judges and hopefully more justices. I would also like to thank the Moot Court Association for organizing and putting this together. I also would like to thank the Government Law College. I see that this is the second edition, so it's great to see that this is becoming a yearly competition. I'd also like to thank the Wildlife Conservation Trust for bringing in their expertise to this, and the panelists, and of course the participants who've actually made this moot court what it is today. And finally, I'd like to also thank the Initiative for Climate Action team, which includes Anaga and Shivangi. I know how hard they've been working behind the scenes to put the workbook together and put all of the material that we've been discussing today together. So I'd like to just take 2 minutes, since I'm not the lawyer in this group, to say that two of my co-founders actually are lawyers. So I have, and half of our community today is also comprising of lawyers and either students or practicing lawyers and litigators. So I've really, in the last 6-7 months that we've been an organization, I've seen the role and the value that lawyers and the law can actually have in the climate action journey. And that's what we are about in the Initiative for Climate Action. So I'm really glad to see that there are more forums like this where we are discussing issues relating to conservation, but also we are trying to bring in the climate action perspective here. And really what we see here, and increasingly I'm starting to say climate justice and sustainability, because I really see climate justice as the main focus here beyond climate action. Climate action to some extent is going to zero carbon futures, where we're not putting more greenhouse gases and increasing the temperature of the earth and the atmosphere. However, that does not ensure vulnerable communities and underrepresented communities are getting access to the resources that they rightfully deserve. So I'm glad to see that was also the theme of today's or this moot court, was to actually discuss how underrepresented communities can be provided some sort of justice where the law and the lawyers play that role. So I'm really happy to see this, and this is a great partnership that we're very honored to be part of. I'm really looking forward to more such kind of discussions, more education around climate action and conservation with the legal fraternity, and also opportunities for lawyers to actually start working in this space, in the climate action space, because we definitely need a lot of legal expertise to accelerate our journey towards a kind of zero carbon and climate justice future. So I'm glad to see this partnership, and I look forward to seeing a lot more from this group. Thank you very much.
Thank you so much, sir. We also have with us Professor Sonali Mathur, who is the professor in charge of the Moot Court Association and also a professor at the Government Law College. Her guidance and direction have been invaluable to the committee and its functioning. We would like to request Professor Mathur to kindly say a few words.
Good evening, respected judges of the Honorable Bombay High Court, office bearers of the Wildlife Conservation Trust, Initiative for Climate Action, esteemed guests, participants, and students. As the professor in charge of the Moot Court Association and Government Law College, I take immense pleasure to see everyone gathered here today at the close of the second edition of the Wildlife Protection Government Law College National Online Moot Court Competition. This moot is really special and probably the only moot whose theme revolves around the important issue of conservation of wildlife and natural habitat. It is a joint venture of the Government Law College, the Wildlife Conservation Trust, and our knowledge partner, the Initiative for Climate Action. This year has been a year of nature trumping mankind, where it has gotten the opportunity to heal and revive with all of us locked in to our homes. But it has also been a year for all of us to reflect on what is truly important and hopefully start or continue to take concrete steps in the preservation of the environment and the wildlife. The purpose of this moot was to promote a keen understanding of environmental law and also to sensitize students towards the conservation of wildlife. I believe the students participating in this moot today will certainly be the flag bearers of this important cause once they graduate and get into the field of law. I would like to take a moment to express my sincere gratitude to the judges of the final rounds for sparing their valuable time this Sunday evening. Honorable Mr. Justice M.S. Sonak, Honorable Ms. Justice Bharti Dangre, Honorable Mr. Justice Abhay Ahuja, and I would also like to thank Honorable Mr. Justice G.S. Patel for gracing us with his presence and his invaluable support to the competition. Would also like to thank the office bearers and the members of the Wildlife Conservation Trust for their constant support. In particular, I'd like to thank Dr. Anish Andheria, Mr. Rishikesh Chavan, Mrs. Anukriti Upadhyay, Ms. C. Samyukta. And I would also like to thank Mr. Jay Warrior from the Initiative of Climate Action for his enormous support. It was an absolute pleasure to watch the young legal minds from across the country displaying their brilliance and advocacy during the last 2 days. I would like to thank all our participants who have spent months preparing for this competition and for their brilliant performance. Lastly, and not the least, I would like to thank the Moot Court Association, Ruchi and her team, who have tirelessly promoted and encouraged the development of mooting by organizing these prestigious moots. I would like to thank all our esteemed guests for gracing us with their presence today, and thank you once again.
Thank you, ma'am. We would like to move on to thank our judges for this evening. We have with us Honorable Shri Justice M.S. Sonak, who secured his LLB from Goa with a first class. He enrolled as an advocate on the rolls of the Bar Council of Maharashtra and Goa in 1988 and practiced at the Panji bench of the High Court of Judicature. In Bombay, he practiced civil, constitutional, labor, environmental, commercial, tax, and company law, among others, and also indulged in public interest litigations. His lordship was also an additional standing counsel for the central government and a special counsel for the state government in statutory corporations. Honorable Justice Sonak was elevated as an additional judge of the High Court of Judicature at Bombay in 2013. I would like to thank your Lordship for sparing your valuable time and gracing our occasion with your presence.
Thank you.
Yeah. Thank you so much for being with us, Your Lordship. Moving on, we have with us Honorable Srimati Justice Bharti Dangre, who obtained her degree in LLB from Dr. Babasaheb Ambedkar College of Law at Nagpur. She obtained a postgraduate degree in commercial laws in the year 1992. She practiced in the district court, high court, and extensively handled service matters before the service tribunals. As a government counsel, her ladyship dealt with civil and criminal matters, as well as various constitutional issues and several public interest litigations. Her ladyship was a standing counsel for the High Court of Judicature, Nagpur Improvement Trust. She was a special counsel for the Forest Department. She worked as a contributory lecturer in law and management studies and is also a trained mediator. Her ladyship was elevated as the additional judge of the Bombay High Court in 2017. We are honored to have you with us today, and I request your ladyship to enlighten us with a few words of wisdom.
A very good evening to all of you. It's indeed a pleasure for the last 1.5 hours when we judged the finalists of the Moot Court competition. This is fortunately the second time and probably the second moot. And I had the opportunity to judge the first Moot Court competition also, which was a Medeni fort on part of the Government Law College. And therefore, I have the benefit. I'm the second one, and probably I hope and trust that in the next year and the coming years, and I will be always invited for at least for the wildlife Moot Court competition. My respected brother Mahesh, Abhay, the principal of the Government Law College, Dr. Andheria, the president of the Wildlife Conservation Trust, the other office bearers of the trust, and the participants, as well as the organizers and the members of the Moot Court organization. A good evening. I had the good fortune of appearing for the Forest Department, and I'm proud to say that I am from Nagpur. And out of the 17 wildlife sanctuaries which are declared as wildlife sanctuaries in Maharashtra, if you name, the most famous one are located nearby Nagpur. So I had a good fortune of being a part and grown up in these sanctuaries, in the sense that any vacation, any weekend, we had a passion of going either to Pench, Tadoba, Andheri. And apart from Pench, Tadoba, Andheri, now you have the Umbred Karandla Wildlife Sanctuary, you have the Bay Boar Sanctuary, the oldest Melghat Sanctuary, Nagzira, Navegaon. These are all wildlife sanctuaries which are near Nagpur. And I think for Bombay people, it is only when while watching tiger, you must be aware of only one wildlife sanctuary, that is Tadoba. The most exciting animal to be spotted, which is of course, if you are lucky, it's the Tadoba Wildlife Sanctuary. But whenever I invite even my brother judges to come to Nagpur, the blank explanation is this: you can see tiger only when it is 45 degrees, and Bombay people cannot tolerate that heat. But indeed, jokes apart, the wildlife around Nagpur is really something which is very enthralling. And once you go to visit the forest, then it's really a passion which you develop. Once you go move around for the whole day, one safari, second safari, then when you don't spot a tiger, then you are excited to visit other one. And there are instances when we went on a first round, saw the tiger 10 minutes and we came back. Because the most exciting thing for Tadoba and all other forests near Nagpur is the tiger. All said and done, I was also a special counsel for the Forest Department. So I was responsible I participated in many PIs, which particularly related to relocation of the forest dwellers who were found in the core area of Pench Forest and specifically Tadoba Andheri. Now, after a lot of efforts, initially it was a very difficult procedure because the the rehabilitation packages had to be prepared, the consent had to be obtained, the Gram Panchayat's consent was required to be obtained. But now, of course, the government has made it compulsory that 2/3 of the forest dwellers should give their consent, and in absence of their consent, they cannot be moved and shifted out. But if you go to all these wildlife sanctuaries now, you'll find that there are only villages located in some of the buffer zones, but most of the core areas, the forest, the actual forest dwellers have been removed out and engaged in some other activity, and they have been properly rehabilitated. The Moot proposition, which was taken up today for discussion, was indeed very experimental in the sense it is an ongoing topic, and the debate between the man-animal conflict, which is still, as Dr. Andheriya had explained, that the man-animal conflict is the main issue on which the forest department as well as the government is focused on. When at the same time, the rights of the forest dwellers have to be recognized and have to be respected on one hand, as we have seen, and I could see that the students have very well attempted to strike a balance. I remember one of the council appearing for the state has very rightly argued that they will come up with a rehabilitation package which will reduce their dependency on the forest produce, and that would bring them into mainstream of life. Because if we go into these villages which were initially located, there were small pockets of villages who were rather not completely untouched with the urban population, and the means of livelihood was only forest produce. In Gadchiroli district and all, you will find that there are maua flowers, which is now, you'll find that various produce of these flowers are converted into jam, sauces, other products apart from the country liquor, and a lot of tribals are being engaged into this activity. So I could see the blend of the arguments from the petitioner sides and the respondents, who very enthusiastically and practically argued that there is a need for rehabilitation of these forest dwellers so that the forest is also conserved, as well as these forest dwellers whose rights are sought to be protected by the enacted, they are not also deprived of their rights. All these students have performed very well, and it was indeed an excellent deliberation on the latest issue dealing with man-animal conflict as well as conservation of forest and dealing with the right of tribals. Of course, the time is the time allotted to me is some 7 minutes, but I would not resist myself from referring to a quote which has been quoted by Justice Chinnappa Reddy in the famous PIL of Sachidananda Pandey when it was dealing with a public interest litigation and bring up of a hotel in state of West Bengal. 132 years ago in 1854, the wise Indian chief of Settle replied to the offer of the great white chief in Washington to buy their land. And Justice Chinnappa Reddy, in the opening of his judgment, has said that he has quoted the entire poem. He described that it is something which is so profound, so beautiful, so timeless that I cannot resist from quoting the whole verse, which is borrowed from the Parivaran, volume number 1. Of course, I'm not reading you the whole thing, but some experts I really can't resist myself from referring to. It reads, how can you buy or sell the sky, the warmth of the land? The idea is strange to us. If we do not own the freshness of the air and the sparkle of the water, how can you buy them? We are part of the earth and it is part of us. The perfumed flowers are our sisters. The horse, the great eagle, these are our brothers. The rocky crest, the juices in the meadows, the body of heat of the pony, and man all belong to the same family. This shining water moves in the streams, and rivers is not just water, but blood of our ancestors. If we sell you land, you must remember that it is sacred, and you must teach your children that it is sacred, and that each ghostly reflection in the clear water of the lake tells us of the events and memories in life of people. The water's murmur is the voice of my father's father. The rivers are our brothers. They quench our thirst. In the ultimate paragraph, it says, you must teach your children that the ground beneath their feet is the ashes of our grandfathers, so that they will respect the land. Tell your children that earth is rich with lives of our kin. Teach your children what we have taught our children, that the earth is the sun mother. Whatever befalls the earth befalls the son of the earth. If men spit upon the ground, they spit upon themselves. This is what all we know. The earth belongs to man. Earth does not belong to man. The man belongs to the earth. This is we know. All things are connected like the blood which unites one family. All things are connected. So this is very beautifully what has been quoted is this is the real image which we have to create in the children and these students of the new generation. I must congratulate the Government Law College Mumbai for organizing. We have so many moot court competitions where we really test the skills of the upcoming lawyers, how they argue. Of course, there are various legal issues normally which we see and come across are complicated issues like the intellectual property rights and all other complicated issues. But this is a unique endeavor where we also imbibe into the students the knowledge about the forest laws, and not only this, the interest in the forest. And I hope and trust that the apart from arguing the matters here, the students would be rather excited to go and really visit the forest, and probably the organizers and along with the wildlife protection trust would of course assist the students. And I must say that instead of complimenting the students by presenting a trophy, the winner trip should be awarded a free trip in Melghat, Tadoba Andheri, whatever forest reserve, and that would be a really great dedication towards the cause which has been espoused by the wildlife trust in association with the Government Law College. Thank you very much. The results will be announced soon. Both the teams, and I must congratulate each one of the speaker as well as the researcher who had gone in depth and conducted a research. And we must applaud whether the team is first winner or the runner. Thank you very much. And congratulations. Best of luck once again. Thank you.
Thank you, Your Ladyship. We also have the privilege of having in our presence Honorable Shri Justice Abhay Ahuja, who received his LLB from the Government Law College Mumbai and LLM from the University of Mumbai in the year 1994. He enrolled as an advocate on record Supreme Court of India in the year 2000. He was also a professor at the Government Law College in Mumbai. Justice Ahuja primarily practiced commercial, corporate, property and tax laws while representing the government, various banks, corporates and individuals before the Supreme Court, the Bombay High Court and the Delhi High Court amongst others. He was appointed as a senior standing counsel by the Income Tax Department and as a senior panel counsel by the Government of India as well as the Insolvency and Bankruptcy Board of India, representing the government in many important matters till his elevation as a judge of the Bombay High Court on March 4th, 2020. We are honored to have you with us and we request you to address the audience now. Excuse me, sir, you're on mute.
Oh, I'm so sorry. Thank you for the generous introduction. Respected senior colleagues, Justice Patel, Justice Sonak, and Justice Dangre. Dr. Kale, Principal, Government Law College, and Joint Director of Education. Professor Mathur, Professor in Charge, Moot Court Association of the Government Law College. Dr. Anish Andheria and Anukriti Sharma, Wildlife Conservation Trust, Mumbai. Mr. Jay Warrior, founder of the Climate Change Initiative. Ms. Ruchi Wagralkar, General Secretary, Moot Court Association, Government Law College. Other office bearers of the Wildlife Conservation Trust, as well as the Moot Court Association. Dignitaries, dear participants and students, ladies and gentlemen. Good evening. In fact, before I start, I must say that I share all the sentiments expressed by my senior colleague, Justice Dangre, and it has indeed been a proud privilege to be associated with this second Wildlife Protection Online Moot Court Competition 2020 in association with the Wildlife Conservation Trust and the Initiative for Climate Action. Though I have been associated with the Government Law College since, I think, 2 decades, and also participated in the moot court competitions. I must say that every time I'm invited for the moots, it is always a refreshing experience. And this time it is even more, considering I have had the good fortune of my senior colleagues at the bench. I'm happy to be with all of you this evening. According to the ancient Indian thought, an ecological balance can be achieved when human beings maintain harmony between Deha Desha, that is the human body, and the Bhumi Desha, that is the habitat. Nature conservation should be an integral part of our human ethos rather than legislating or for the courts to maintain and direct their protection. I think it should be part of our daily life. If our forefathers would not have conserved nature, then we would not be in a position to enjoy whatever green cover we have had the benefit of enjoying. And I must say that I would also like to go to the Nagpur sanctuaries with all the students whenever it is organized. Because I think that is the real part of this whole competition, to go and actually witness the green cover which is preserved in and around Nagpur. I would also like to quote Leo Tolstoy, who said that one of the first conditions of happiness is that the link between man and nature shall not be broken. And that is really the purpose of having these kind of competitions. Also, Mahatma Gandhi said, he went a step further actually. He said the earth, the air, the land, and the water are not an inheritance from our forefathers, but on loan from our children. So we have to hand over to them at least as it was handed over to us. And that is really what I think is important for not only the lawmakers, but also the law administrators as well as the government and the NGOs to ensure that we do not spoil nature beyond which it has already been spoiled. Dr. Andheria said that forest conservation is like a tug of war. And it is true that this is between livelihood and conservation of the forests. And I was quite surprised when he said that the sensitive habitats of highly endangered wildlife occupy just less than 5% of India's landscape. That itself rings a bell to the critical situation we are in. And I believe this would have led to the enactment of the FRA and for declaration of the critical wildlife habitats, of which we have seen the discussion this evening. I'm not sure if the pendulum, as stated by Dr. Andheria, rests in the middle still. I'm sure quite a bit of work will need to be done to achieve that state. But I'm very glad and grateful that these deliberations are taking place at the level of our student community. And today we have this online platform. And because of this online platform, I'm sure there are many more people who would have access to hearing what our illustrious speakers before have spoken. I must therefore congratulate the Moot Court Association of the Government Law College, the Wildlife Conservation Trust, and the Initiative for Climate Change, Climate Action, who have collaborated to host this competition, as it will not only increase the awareness of this subject, but as I've experienced today, in the last few hours, from the ignited minds who have researched, argued so wonderfully into the nuances and intricacies of this rather important subject matter. Also, the proposal to evolve from climate change to climate justice is an interesting concept, as has been spoken by one of the earlier speakers. And I think this is something we need to think about. Coming to our competition, I have been directed by Justice Patel to comment on your performance. The results are awaited. There are two teams. Obviously, one will be first and the other will be second. This is the structure of how competitions are done. But believe me, the participants were extraordinary. The arguments were top class. And I must congratulate all of you for having put in this hard work. My heartiest congratulations also to all the students of all the 16 teams participating in this competition, because without your effort and participation, we wouldn't have seen such a rich class today. I have personally got to learn and be educated in this area of law thanks to the bench memorandum sent to me, and I must thank all of you here today. Thank you, Government Law College, Wildlife Conservation Trust, Initiative for Climate Action, and above all the student participants and my senior colleagues. Thank you very much. All the best.
Thank you so much for that, Justice Ahuja. I would also like to thank Honorable Justice G.S. Patel as the special invitee for this evening. He is a graduate of St. Xavier's College and Government Law College. He started practice in 1987 in Mumbai, working on commercial, corporate, and civil litigations, and also appearing in a large number of environmental public interest litigations. Justice Patel received the first international fellowship at the Pacific Energy and Resources Center, California, in environmental law. His lordship served as the honorary secretary of the prestigious Bombay Bar Association for 2 3-year terms from 1999 to 2005, and served on the association's standing committee till his appointment as a High Court judge. From 2008 to 2011, he was a part-time lecturer in administrative law, constitutional law, and environmental law at Government Law College. His lordship was elevated as a judge of the Honorable Bombay High Court on the 21st of June 2013. We would like to thank him for his continuous guidance and support towards the Moot Court Association and Government Law College in all our endeavors and events.
We would also like to thank Ms. Samyukta, the head of forensics at the Wildlife Conservation Trust, for her continued support, guidance, and encouragement through the process of organizing this moot.
We now come to the valedictory function for this evening. All the winners will be given an e-certificate and a cash prize. We now request Honorable Shri Justice Abhay Ahuja to announce the award for the second best speaker overall through the course of the competition.
Are there any guesses? Are there any guesses? Yes, the participating teams this evening. Well, all of you are in for a surprise. The second best speaker goes to Shruti Mishra of NLIU Bhopal.
Thank you, sir. Thank you so much.
Thank you, Your Lordship. We now request Honorable Justice Srimati Bharti Rangre to announce the results for the best speaker.
Madam, you are on mute. Ms. Vagalkar?
The best speaker, the award for the best speaker goes to Mr. Devansh Gupta.
Thank you, Your Ladyship. We now come to the most anticipated moment of the evening, the awards for the best team and the second best team. We request Honorable Mr. Justice Sonak to kindly announce the award for the best team of the second Wildlife Protection Government Law College National Online Moot Court Competition.
Thank you very much, Riya. I must congratulate both the teams for making our task so much difficult. The best team is the National Law Institute, University Bhopal, comprising Mr. Lokesh Rajoria, Ms. Shruti Mishra, and Ms. Pooja. Congratulations. And the second best team, Symbiosis Law School, Noida, comprising Ms. Anmol Mathur, Mr. Vaibhav Jeswani, and Mr. Marvel Soni. Again, congratulations. First and second are only numbers. Let me assure you on behalf of my sister and brother that both the teams were excellent, and we applaud your performance and congratulate you for that. Thank you very much.
If I have the permission to say one line here.
Yes, please.
Yes, please.
So as suggested by Honorable Justice Ahuja, I think Wildlife Conservation Trust will be more than happy to invite the winners for a trip to one of the forests of Maharashtra.
That was suggested by my senior colleague, Justice Dangre. So I think the credit for that should go to her.
Credit goes to her. She has been a stalwart, and a supporter of the moot court from the very beginning. And I think I believe that if you see the tiger walking in front of you and breathing the same air as you do, you will fall in love with nature. And if you fall in love with nature, then you will ask yourself, how can you help nature? And so in a way, I am just trying to manipulate these students using the tiger because we need, in the last 5 to 10 years, wildlife of India has a lot to thank, has to thank the courts. Without the courts, we would have had a crisis at hands. And in fact, the Supreme Court, the High Courts, and the NGT, they have all pitched in a very, very big way. And they have been the mouthpiece for the wildlife. Whenever I talk to the politicians, I say that you only listen to human beings because they vote. I wish, as one of the speakers was talking, that we give the voting rights to every grass blade, every tree, every tiger, and every bird that flies on this planet. But till that happens, at least we need lawyers and judges who will support the unsung heroes, because of whom we are enjoying the ecosystem services sitting miles away from the forests. So thank you once again, and I'm very happy that these teams have made it so far. And I would also, in fact, suggest the Samyukta, if it's possible, we should also invite the runners-up when we plan this trip, so that both the teams can also meet in person, because I think this is the 5th best thing that we can do, being in front of each other through this silly digital format. And so hopefully we can get rid of Corona in the next 4-5 months. Whenever that happens, this invitation holds for all these people, and of course all the justices as well.
Yes.
Who are my guests.
Anish, why not the judges who judge the competition?
So I mentioned that obviously, but there you will be the host. So we will organize it, but you will have to take them and show them the tigers that you are so much in love with. So thank you, everybody.
Thank you.
Thank you, sir. Hearty congratulations to both the teams and the participants. Their days of hard work and sincere efforts have finally borne fruit.
Finally, I would like to thank all the judges, the participants, the panelists for the day, and lastly, the General Secretary and the Assistant General Secretary of the Moot Court Association of Government Law College, Ms. Ruchi Vagralkar and Mr. Devavrat Nimbalkar, who have not only been a pillar of support and guidance, but also great mentors to the entire committee.
The success of this prestigious competition can be attributed to their unconditional dedication and perseverance. Through their strong leadership, the Moot Court Association has achieved higher standards of excellence in all their endeavors. We now request them to give the vote of thanks.
Honorable Judges of the Bombay High Court, Honorable Mr. Justice G.S. Patel, Honorable Mr. Justice M.S. Sonak, Honorable Srimati Justice Bharati Dangre, and Honorable Mr. Justice Abhay Ahuja, Dr. Anish Andheriya, Mr. Jay Warrior, professors, participants, ladies and gentlemen. It has truly been a privilege for the Moot Court Association of Government Law College to organize and host this event in association with the Wildlife Conservation Trust and the Initiative for Climate Action to raise environmental awareness and instill the spirit of sustainable development in future lawyers of our country. Our nation is plagued by the growing insensitivity towards the protection of our wildlife and forests. India has a rich biodiversity which is rapidly being degraded due to unchecked urbanization. The main object behind this moot court competition is to encourage law students all over the nation to actively work towards protecting the environment and our rich ecosystem. The Moot Court Association of Government Law College will be ever indebted to Honorable Mr. Justice M.S. Sonak for his invaluable time. We sincerely thank His Lordship for consenting to preside over the final round of arguments and the valedictory function this evening. We would like to thank Honorable Srimati Justice Bharti Dangre for taking out her valuable time and consenting to judge the final round of arguments, as well as for her constant support in all our endeavors over the years. We would like to thank Honorable Mr. Justice Abhay Ahuja for his constant support in several of the Moot Court Association's endeavors in the past, and we once again thank His Lordship for his continued encouragement and for consenting to judge today's competition. On behalf of the Moot Court Association of Government Law College, I would sincerely like to thank Honorable Mr. Justice G.S. Patel, our special invitee for this evening, for gracing us with his presence and for sparing his valuable time. We are indeed grateful for all the assistance and encouragement provided by him throughout the organization of this competition and to all students of Government Law College. I extend my sincere gratitude to Dr. Anish Andheria, President of the Wildlife Conservation Trust. His cooperation and guidance in the organization of this event has been invaluable to us, and we are deeply grateful to him for giving us the opportunity to host this competition. We would like to extend our sincere gratitude to Mrs. Anukriti Upadhyay for unconditional support throughout the organization of this competition. She has been of great assistance to us, not only during the course of the competition, but during the days preceding the competition as well.
This event would not have been possible without the relentless guidance and support of Ms. C. Samyukta. She has supported us throughout this moot by taking an active initiative in the organization of this event. Her help has been invaluable to us. I would also like to thank the entire team of the Wildlife Conservation Trust who have worked very hard behind the scenes to make this competition a reality. I would now like to thank Mr. Jay Warrior and Ms. Anagha Sasidharan for the Initiative for Climate Action, our knowledge partners for this competition. Her valuable insight and experience in the field of conservation has greatly contributed to the success of this competition. This thank you speech would be incomplete without thanking the Moot proposition drafters who have also been incredibly helpful to the Moot Court Association over the years, Ms. Shivangi Adani and Mr. Akhilesh Menazaz. I would also like to thank our principal, Dr. Rohidas Kale, Professor Rachita Ratho, Professor Kishu Daswani, and Professor Malaka Devendra for being a source of inspiration and for their continuous encouragement of student activities in the college. Professor Sonali Mathur's contribution and significance to the Moot Court Association is very difficult to express in a few words. Her constant commitment and unconditional support to the MCA goes a long way in ensuring the success of all our endeavors. I would now like to thank the members of the Moot Court Association for the constant devotion towards the success of this competition. And in particular, I would like to thank Mr. Devavrat Nimalkar, the Assistant General Secretary of MCA, and the other post holders of MCA, Gaurang Samir, Aman Saraf, Aditya Deshankar, Akshita Tiwari, Nishda Chaudhary, Binaisha Hansotia, Ruhan Shah, Abhishek Raj, Riya Narachanya, and Riya Doshi. I would also like to extend my heartfelt gratitude to the former General Secretaries, Ms. Shivangi Adani, Mr. Yash Shiralkar, Ms. Anjali Karunakaran, and Mr. Bharatam Mirchandani for their contribution and support to the MCA. The advisory board of the Moot Court Association, comprising of Mr. Ruben Vakil, Mr. Feroz Patel, and Mr. Shanay Bafna, have been a constant pillar of support and guidance, and I would like to express my heartfelt gratitude to them for their immense contribution. And finally, I would like to extend my gratitude to all teams for participating in this competition and supporting us as we organize this edition of the Moot Online. We look forward to hosting you again. I hope that all participants will incorporate an eco-friendlier approach in their daily lives. Saving the environment is no easy task, but even the smallest changes in our daily routines can make the biggest difference. And starting today, by changing our habits, we can establish a movement which may one day truly result in a greener India. Thank you and have a very pleasant evening.
you everybody once again.
Thank you, everyone. Have a
Thank you, everyone.
Thanks, everyone.